When you're dealing with child custody agreements, it can really feel like you're lost in a maze. It's overwhelming.
Totally. There's so much on the line, your rights, your child's future, and the legal stuff can seem, well, pretty confusing.
Right. People think maybe a quick chat, a handshake, or, grabbing something online will work.
Exactly. And this legal guide for Illinois we're looking at today really flags those informal ways. They often lead to big problems. Think unenforceable handwritten notes, rejected templates.
Verbal agreements that just don't hold up in court.
Precisely. Or agreements so vague nobody knows how to enforce them.
Okay, so that's why we're doing this deep dive today.
Right.
We're using this Illinois guide to sort of unpack child custody agreements. The mission is really to help you understand how to make these things legally solid. Avoid those mistakes, protect your rights, and crucially keep the child's well-being front and center, like Illinois law demands.
Good goal. So let's start at square one. What is a child custody agreement officially in Illinois?
Think of it as the legal rule book for co-parenting after you separate. It's the document that says who does what, when, and how regarding the kids.
And the guiding principle.
Always the child's best interests. That's paramount in Illinois.
Okay. And these agreements generally have two core parts, right? Parental responsibilities and parenting time.
Yeah, exactly. Parental responsibilities, that's basically legal custody. It's about the big decisions.
Like education, healthcare.
Right. School choices, medical treatments, religious upbringing, if that applies, even big extracurriculars like travel teams or something.
Got it. And parenting time.
That's the schedule, the day-to-day. Often called physical custody. It maps out the regular weekly plan, holidays, vacations, birthdays, the practical stuff.
And the key here, according to the guide, is detail.
Oh, absolutely. Illinois courts won't enforce something fuzzy. You need a detailed parenting schedule.
Yeah.
Specific days, times, pickup spots.
Not just dad gets weekends.
Definitely not. Weekdays, weekends, school breaks, holidays, it all needs to be spelled out. And clear allocation of those big decision-making powers.
What if decisions are shared?
Then you need a plan B baked right in. A dispute resolution process like mediation, so you don't have to run to court for every single disagreement.
Makes sense. Plan ahead. What else is crucial?
Terms for making changes down the road, modification clauses. And enforcement clauses, what happens if someone doesn't stick to the plan?
So vague agreements are basically useless in court.
Pretty much. The guide is clear. Illinois courts need specifics to enforce anything.
Okay, so you've got an agreement drafted. It's not automatically approved, though.
Nope. A judge has to review it. Even if both parents agree, the judge checks if it meets legal standards and, again, serves the child's best interests.
What are they looking for during that review?
Well, stability for the child is huge.
Mm-hmm.
Does the plan provide consistency? They also look at whether the parents seem able to cooperate.
And the agreement itself.
Is it clear? Is it actually enforceable? Is the schedule practical? Does it work with school, activities, parents' jobs? And is there a solid communication plan between the parents?
What if the judge doesn't like it? If they reject it?
Could happen. They might kick it back and tell you what needs changing. Or they could order mediation to help you sort out the issues.
And if parents still can't agree?
Then the judge might just impose their own parenting plan based on what they think is best for the child. So how do parents create something that works and gets approved? Sounds like customization is key.
Absolutely. Forget generic templates. It needs to fit your child, your family. The schedule should align with the child's life, school, activities, their emotional needs, not some rigid one-size-fits-all thing.
Right. And being super clear on who decides what for medical, school, etc.
Essential. Prevents conflict later. And like we mentioned, having that dispute resolution process defined, mediation, negotiation, whatever, can save a ton of grief and money.
What about planning for changes? Life happens, right?
Definitely. Building in how you'll handle things like a potential move, job changes, or just the child getting older and having different needs. That's smart. Courts allow modifications for big changes, but having a process helps. The guide also mentioned communication rules.
Yeah, like how quickly you need to respond to non-urgent versus urgent things, what methods to use email and app, how you share school info or medical updates, emergency plans, even how you document agreed schedule changes.
That level of detail sounds really helpful.
It is. Thinking through practical stuff too. School calendars, activity transport, work schedules, holiday planning way ahead, transition logistics, makeup time procedures. Getting granular prevents fights.
Which brings us back to why those online templates can be so risky.
Exactly. They often miss Illinois-specific laws, lack teeth for enforcement, use vague language, and just ignore your family's unique situation.
So the takeaway is get a lawyer involved.
Strongly recommended. This guide really hammers that home. An attorney ensures it meets Illinois standards, spots loopholes, protects your rights, helps with complex issues, and anticipates future problems.
Seems like money well spent up front.
For sure. The cost and stress of fixing a bad agreement later, way higher. Especially the guide notes. If you're dealing with a difficult or controlling co-parent, clear, specific language is your shield.
Okay, let's quickly recap the common mistakes that weaken these agreements.
Number 1, vague schedules. Missing times, locations, holiday specifics. 2, no conflict resolution plan for joint decisions. 3, not addressing relocation rules. Moving over 25 miles usually needs court approval in Illinois if there's no consent.
What else?
Relying on verbal agreements, big mistake, totally unenforceable, unclear decision-making authority, and of course skipping that legal review.
Good list. What about changing an agreement later? Is that possible?
Yes, modifications are allowed if there's been a substantial change in circumstances. Maybe a parent's job or living situation changes drastically, or the current plan just isn't working for the child anymore. Sometimes repeated violations can trigger it too.
How does that work legally?
Usually you try mediation first if you agree to that, or the court orders it. If that doesn't work, you file a formal petition to modify with the court. If you both agree on the changes, court approval is often quite quick.
Any restrictions?
Yeah, there's generally a 2-year waiting period after the initial order before you can modify the decision-making responsibilities, unless you can show the child is seriously endangered by the current situation. Parenting time is often easier to modify sooner, if needed, and if someone just ignores the agreement. Enforcement.
Courts take that seriously. First step, document everything. Every missed visit, late exchange, failure to communicate as agreed. Keep records.
Then what?
You might try mediation again. Often it's required. If that fails or isn't appropriate, you file a motion for enforcement, usually called a petition for rule to show cause, basically asking the judge to hold the other parent accountable. And what can the court do?
If they find willful violation, lots of things. Order make-up parenting time, impose fines or attorney fees, maybe even modify the custody arrangement if the violations are persistent and harming the child's well-being.
It always comes back to the child's best interest, though.
Always. Stability is key, but repeated violations show the plan isn't working or one parent isn't cooperating, which can lead to changes.
Okay, let's wrap this up. Key points people should absolutely remember from our deep dive today.
First, this agreement is a legally binding contract. It protects your rights and your child's stability. Don't treat it lightly.
Second,
Vagueness is your enemy. It leads straight to conflict and court battles. Be specific.
right, and Illinois courts demand that specificity. Detailed, enforceable terms are non-negotiable.
Yep. Also, remember that changing or enforcing the agreement requires following proper legal steps. You can't just decide things informally if you want legal backing.
And the big one?
Get legal help. Seriously. Having an experienced Illinois attorney draft, or at least review your agreement, is the best way to protect yourself and your child and avoid huge problems down the road.
Excellent summary. So, here's something to think about. Considering all these complexities and potential pitfalls we've discussed, what's one key aspect of your own current or future custody arrangements that might need a closer, more legally informed look?
That's a great question to ponder. And remember, for personalized advice tailored to your specific situation, reaching out to experienced Illinois family law attorneys is really the crucial next step. Thanks for joining us for this deep dive.